and they can't move. And it just frustrates me that we're not going to help those people, but you know, we're all worried about the poor landlord. Well, the landlord isn't going to do anything, and there should be consequences.
And if they do the most minimal things,
Right.
like calling the police, they're
Or
exempt.
starting an eviction procedure.
Right.
They're exempt. I just don't understand. So it's, well, anyway, let's go over the bill and start from the beginning, Eric. Thank you.
Are you gonna pull it up online or?
Yes, I can do that. Absolutely. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee about the changes being proposed to S4 in the House. S4, remember, is an activating to reducing crimes of violence associated with juveniles and dangerous weapons. The only caveat I'll point out is that the bill S4 is still in the House Judiciary Committee. So the version we're looking at now is the changes made so far, not necessarily the final
Do
version.
they know we're adjourning next Friday?
I believe so.
Thank you. You weren't, that was a rhetorical question.
When you start calling him Representative Lalonde, we'll know.
Yes, right, right.
Just to be clear, it was a rhetorical question.
Thank you. But anyway, yeah, so it's still being looked at and further changes potentially coming. Senators here, so I share the screen so we can look at what the proposed changes are, at least at this point.
Yep.
All right, let's see here.
Yeah.
Yeah, here
Thank you.
So, as usual, the changes at this point anyway are highlighted. So the first section, this involves the Big 12. So that's what's, remember that
Yep.
section of the bill as S4 as it passed the Senate involved some additional offenses being added to the Big 12. Remember that the original Big 12, although it was 11 at the time, was passed in 1981 when a special session of the legislature. The Senate Judiciary Committee added, if I believe, 6 offenses to the Big 12. Actually, 8 if you count. You'll see in subdivision 5, aggravated murder was added, right?
Yeah.
Murder was one of them, aggravated murder as well. And in subdivision 11, aggravated sexual assault of a child is added as well. Those 2 were left unchanged by the House. But the other additions that were made down here, 13 through 18, have been moved. And I remind you, you may recall, when it came over from the governor, this list was even longer if possible. And what this committee decided to do was to add several of them to the Big 12, but then take actually the majority of them and add them to a study by the Sentencing Commission to consider whether or not the Big 12 should be further expanded to include those. So the ones that you'll see here, 13 through 17 at least, that's carrying a firearm while committing a felony, drug trafficking, human trafficking, aggravated stalking, and attempts. That's 13 through 17. Those have been moved to the
You
study.
remember back in November when you and I were working on this bill? In the beginning, we had those basically the 4 or 5 crimes that passed out of the Senate, but we had 16 as the age. Am I correct in that recollection?
The initial way that it was drafted, that's correct. That it was done slightly differently. Some people, I remember people saying, well, doesn't this effectively create more offenses to the Big 12? And I think that's right. It's a practical, but it was drafted differently.
It was 16, 17, and 18-year-olds that were impacted in the original draft that you and I worked on, and we worked with Chief Doucette in Bennington and Erica Matthews and some others.
Right.
And I think everyone was in agreement on that was a possibility. And then as the administration got involved, and we lowered it when it passed the Senate to any age. But I'm comfortable with the original. I'm not comfortable with this. But I also, can you explain why they took attempts out? Because attempts that would only cover whatever you have in the Big 12,
Correct.
in their version. So,
I think there was just, like with the other offenses, there was concern over whether the Big 12 should be expanded at all.
but
So
thank you.
rather than,
I would say for our purposes, attempts to commit these crimes should be considered. And the fact that you didn't kill the person doesn't mean you didn't shoot at him. You were just a bad shot. Maybe,
yeah. I think there was some
maybe
question.
they didn't practice it.
Can I ask a question
Yeah.
here? So for 17 and attempt, so, moving beyond attempted homicide, there's other offenses. We have human trafficking, aggravated stalking, trafficking,
I'm talking about what they looked.
right? And I'm looking at page
Oh,
3, line 4.
Yep.
How does one attempt human trafficking or attempt aggravated stalking?
Right.
Well, I think the general approach of attempt is that it requires a step toward the commission of the offense. With respect to human trafficking, for example, it sort of depends on the underlying elements of the offense. Could one take a step toward, for example, having someone forced to commit a sexual act for purposes of human trafficking? Could there be a step taken toward that wasn't an actual final commission of the offense? I don't have the elements right off the top of my head, but that would be in theory at least how it will be done. And one thing I'll add about attempts, and I don't know the answer to the question, is that there was some discussion as to whether or not attempts may have been covered by the existing Big 12. I don't see attempts there expressly, whether or not as a matter of practice, the court or the practitioners treat that as a Big 12 offense would be.
If that was the case, it wouldn't do any harm to leave it in. It would make it clear the legislative intent.
Right.
Okay. But
So
I understand that, I didn't mention it yesterday. While I was in quarantine finishing everything that I could possibly do, I went on YouTube and watched the House Judiciary. It was an experience. They're a divergent group, and I feel for Representative Lamont trying to lead that group to any decision. But anyway, my biggest concern is those carrying a firearm personally and the attempts language of what they cut. And, frankly, we have people shooting at each other in the streets of Bennington. We have people holding firearms and, forcing people into sexual acts, forcing people into other things. And they're putting the firearm right on the coffee table. And I've read the affidavit on that. It's horrible. And so,
Chair,
pardon me, go ahead.
I'm just to specify, you're talking about of the struck language,
Yep.
line 17, page 2.
Yep.
And line 4 on page 3.
Yep.
Okay.
The others could be studied by the Sentencing Commission.
Mhm.
I think we could live with that. If you want to go to section, next changes, right?
before we do that, and I've lost my screen share, but now it appears to be coming back, and I'll pull it back up. So I did not mention the last one, subdivision 18.
Oh,
So, and this is related to the next section of the bill. So you remember, this has to do with violations of conditions of release. You remember the theory behind that is that ordinarily a violations of conditions of release charge is a misdemeanor. It's a non-Big 12 offense. So ordinarily, if someone gets charged with that, it would go to the family division, right? It's not a Big 12, so it would be brought in the family division. However, if the case is already in the criminal division, because the person was transferred up, which sometimes happens, then that would result in the same case having the criminal procedure going on in the criminal division and the violations of conditions of release for the same offense going on in the family division. So that's why this committee passed that language in subdivision 18 to provide that if it's a violation of conditions released to what related to a Big 12 offense, that gets brought, that's a Big 12 offense too. So that the proceedings involving the same case are taking place in front of the same court, in front of the same judge. So they're consolidated. That was the idea. So, but the Judiciary Committee felt that that was a good policy, but that didn't want to actually add it to the Big 12. So they went about it a different way. And that's what the background to section 2. So they do effectuate the same result, but by doing that with a different method, which is to take it. And it makes some sense that if you're talking about, they're going to move it anywhere, to move it here, which talks about where do delinquency proceedings get commenced. So they're just rephrasing it, and this will be new subdivision 2, which is just tracked on the same existing language that you see on lines 1 through 6. And that 1 through 6, basically, what that's saying is the idea that we've talked about many times in this committee, which is that a Big 12 offense starts in the criminal division. That's the translation of lines 1 through 6. Okay, right? That's what happens. So subdivision 2 says, all right, what else is going to start in the criminal division? Any proceeding, and again, translation, what we just looked at. If it's a violation of conditions of release for a Big 12 offense, that starts in the criminal division too. That's a lot of language, but it's necessary to articulate the same standard that you had before, but that's the gist of it. So that way you have the same result, which is the proceedings take place in front of the same court.
So that's lines 18 on page 6 to 6 on page 7, right?
Actually, yeah, that's existing statute. The new language, you're right, you go on to page 7, you start at line 7, page 7. And that goes all the way down, and that goes right to the bottom of the page, line 21.
And that does what, thank you. And that does what we did in the other division.
Exactly, exactly.
And it's basically the same.
It is, does the same result.
Thank you.
Yeah. So section 3 and 4, you see are both struck, and these are the related provisions involving using a premises for either drug trafficking, which is the existing law. Now, there's an existing law on penalties for knowingly permitting sale or dispensing of regulated drugs in a building, in a dwelling. And remember the committee made a few changes to that. For example, you added recklessly, right? And also you got rid of the dispensing. I think you remember that part. The committee was concerned that you didn't want to criminalize it just because somebody was handing a drug to somebody else. And you also added, you got rid of remember the landlord exemption that had been under existing law, which was it had to be known at the time of the lease, time they signed the lease. So you guys got rid of that and instead went with sort of a safe harbor provision that, as you were indicating earlier, Senator Baruch, if they contact the police or start eviction proceedings.
So did they strike the repeal of existing law?
Yes, everything. They just struck these sections.
So basically, we have no recourse with landlords for that group of individuals stuck in that apartment building.
Well, they struck both sections.
Yeah.
Yeah, no, I mean, so we're left with no recourse. I have no idea why. I mean, I understand that they took out the word dispense. I understand they took out the word reckless, but that was the latest draft I had seen, was just knowingly. And I was trying to understand what they were doing, but now that they've struck the whole section, it's like, what the hell, why don't you just gut the bill? I'm so pissed about this. We better get it. No, I'm not doing the power of attorney bill until next week. I think I'll order it July.
Okay. It's already lying, but if you would, you're better ordering.
No point wasting paper printing the bill out.
I had a good haiku for it.
I hope I remember
Where's
to,
my haiku?
I hope I remember to unlie it before the end of the session.
Well, it'll be on the calendar every day, so it'd be hard to forget.
Wasn't there more testimony on that too, though?
Yeah, the Franklin County Bar is upset.
Yeah.
It's in the water up there. It used to be in the water in Bennington because we got contaminated with PFOA. I don't know what's in the water in St. Albans.
I have no comment.
Anyhow, Eric, please feel free to continue your review of the house.
Yes, will do. So picking up, you'll see you remember a couple of these next two sections deal with the provisions related to defacing a serial number of a firearm and straw purchasers, both of which are federal criminal provisions, and you had enacted a state parallel provision. And the same change is proposed by the House to both of them, which is to strike the language. Remember, you had language in here that said that offense may be considered a violent act for the purposes of determining whether the person is eligible for bail. And again, that would go into the consideration that a court makes when determining whether or not bail is available. I think when it was initially considered in this committee, you may recall that may was a shall. And I think when you had that as a shall, there were significant constitutional concerns with doing it. Changing it to a may, I think alleviates some of those concerns, doesn't resolve it completely, but I think makes it, at least arguably, that this is really just highlighting for the court what it already has the authority to do, and doesn't change anything.
Where are you on? Oh, I'm sorry.
Page 10.
Subsection D.
Yeah, they
Yeah.
struck
Yeah,
struck the may be considered violent for determining whether the person is eligible for bail. You know, it's interesting, the banner article that I provided, they did find several ghost guns yesterday in their bust on Depot Street in Bennington. So, you know, it's a real problem. God almighty. Anyway, I'm not happy with the striking of that. You know, here we are trying, they send over a gun bill, we pass it, we do our work, we do the right thing. And then they have this deals with firearms, and these are people who are committing crimes. They're either straw purchases or they're defacing the serial number. They're committing crimes. Jesus, Mary and Joseph. All right. Well, at least they left fugitives from justice in.
Yes, this next section, you were just segueing through Senator Sears is remember, this is a prohibited person section. So some, again, parallel to federal law in the sense that in addition to people who have been convicted of certain crimes, there are also other categories of people who are prohibited from possessing firearms under federal law, often referred to as prohibited persons. So you mentioned Senator Sears, one of them. I'm looking at page 11, lines 16 through 21. So they didn't change fugitive from justice, as you mentioned, a person subject to a final relief from abuse order, and then the final stalking order. You'll see they did make one change to, and that's clarifying that that it applies if the order prohibits a person from possessing a
I
firearm.
suspect that's okay, just clarifying language. So they didn't change anything else, so you get down to section 8.
Right, and that one, you may recall, that's the existing statute. That's not a statute that you enacted in the bill, but it's existing law that prohibits a person from carrying a dangerous or deadly weapon while committing a felony. And what you had done in the Senate was to add, again, the same idea that you were just talking about, to make it say the court may consider that a violent offense for purposes of bail, with the caveat that if it's only a felony because the monetary value exceeds $900, which is the threshold between a felony and a misdemeanor, that would.
I guess I don't understand why you would strike I don't understand why you would strike current law regarding that.
Well, that was not current.
No,
I see what you're saying. The striking of that you see the strike through, that doesn't strike the current law. That's just indicating that it's struck from the bill. So it would keep current law as is without the proposed change by the Senate at the top of page 13, P1 and 2.
but We provided the exception. Why is it the House of Representatives Committee believes it's okay to carry a firearm and commit a felony?
I think fire.
That was a rhetorical question, Eric.
Oh, sorry. Missing my signal today. Usually don't.
Well, I do wonder what their discussion was around, to the extent you can enlighten us.
I think it was a constitutional concern.
I see.
Well, maybe there's a constitutional issue with the waiting period that they passed. I mean, Colorado passed the same law on waiting periods that we did last week. And has immediately filed suits against the law from a gun owners group in Colorado that it's unconstitutional. So they were comfortable passing that unconstitutional law, but not comfortable passing this law, which is probably constitutional, because people shouldn't be carrying firearms when they're committing felonies.
What, can you provide a bit more of the background of the constitutional concern that they expressed for that section?
Yeah, I think the question is whether or not the bail provisions of the Constitution commit that decision about whether or not an act is violent to the court. And it's not something that the legislature has the authority to determine for the court one way or the other. And that's why I think if it said shall, you would have a significant constitutional issue. But by saying may, again, I don't think it resolves it, but I think it's at least in that sense arguable that you're not usurping the court's authority.
Again, it's the court that decides what's constitutional, not us. And we do our best to provide constitutional provisions in our laws. And we followed the advice of legislative council and struck shall and made it may. So I think I'm comfortable. I would prefer to see this back in.
Is it,
Would,
oh, I'm sorry, go ahead.
I was just gonna say, is it helpful to put a violent felony rather than just a felony?
When I remember at one point, we put some constraints on that to make sure that it didn't include felonies that rise to the level of felonies simply because of the monetary value attached, because I had concern with
Right,
that.
that's 2 on page
Got it.
13, lines 4 through 6
Right.
is where we provide the exemption.
I mean, you know, the example that pops up in my mind is, you know, if it's, let's say, getting a DUI number 3, which I think would be a felony, and you have a gun in the car, is that it for me, in my mind, it wouldn't make sense that would be that it should fall under this category.
Well, I think we can exempt that. I mean, well, we can't because we don't have the bill. But in a conference committee or in trying to work out changes with that other body, we could certainly, I would be opposed to exempting certain crimes that are non-violent. Although DUI can be violent, just ask that poor husband and bride that got killed in South Carolina. Driving in the golf cart, somebody hit him at 65 miles an hour in the back of the golf cart. Yeah.
Eric, in terms of the may,
Mhm.
do judges already have the ability to consider it? In other words, could they now consider it a violent act for the purposes of bail?
Yeah, absolutely. Yeah,
So in that sense, we're not adding to their powers, we're just sort of putting in a marker for emphasis.
that's what I think the argument is, yes, that why use of the term may is more arguably defensible, that it's not actually.
Right, because they already possess that.
Right.
If that's the case, personally, I wouldn't fall on my sword over it if it doesn't add powers to the judge, although it would be, you know, bumping up the importance to the judiciary of doing it.
Continuing the review, there's some language in section 10 on page 14. I don't have a problem with that. That's just the title of the new group.
Yes, also, and above that on the same page, I'm just, I've lost my
Oh, yeah,
screen
yeah.
share again, so I'm trying to pull it back up, but, seem to be working though. We're really through most of the substance. But on that same page, page 14, top of the page, line 5, the change there, you see from age 21 to 22.
Yep.
That is, and this is the provision that that provides the National Instant Criminal Background Check with access to records involving a person under age, as it left the Senate, under age 21 when they attempt to purchase firearm. Remember, this is to make the law consistent with, there we go, consistent with the Bipartisan Safer Communities Act that passed Congress last year, which actually requires NICS to look at this information. The reason that it changed from 21 to 22 is really a technical fix, which is that in Vermont, because youthful offender status can go up through page 21, sorry, not age 21, then if you only had it through age 20, then they wouldn't necessarily be getting all the records. So that's why it's bumped up to 22.
So that's more technical.
Yeah, I think so. And as you mentioned, Senator Sears, that now we're moving on to the section, which is the Community Violence Prevention Program. Remember, this is the grant program to prevent community violence that passed this body. And there's a list of entities. It's run by the Department of Health, but they're to do so in consultation and collaboration with a number of other entities. And this adds the Council for Equitable Youth Justice, which I think is Judge Davenport's, I can't remember what the existing title
I
is.
believe it's Judge Davenport.
Yeah.
But the executive director is Karen Bastine.
That's right, right. And it has a different name.
They had to
currently.
change the name
Right.
because of the new federal law that you just mentioned.
Yes. I can't recall what the existing name is.
CFCPP, the Children and Family
Right. Prevention.
Council on Prevention Programs,
Yeah.
or something
like
very
that.
close to that.
Right. Thank you. So yes, you're right, Senator Sears, they have to be conform with the federal change or changing the name of that entity as well. And in this case, having them be also one of the consulting partners for the program. So no changes to the program other than that. That remains the same. You'll see the no changes, sections 12 and 13. You may recall that's the extension of the raise the age, gives another year of implementation until 2024.
They agreed with us.
Yep, agreed with that. Slightly changed to section 14. This is the part where you said that the DCF is going to have to provide some progress reports to let the legislature know how the raise the age implementation is going, so that they're making progress toward the 2024 implementation date. And the proposal from the House is to add a couple of additional committees who will receive that report. Pardon me?
Of course they would.
Another rhetorical.
Yes.
Okay, just being sure. I got that.
We should have a hand signal for
I
rhetorical.
should, right?
I really don't care who gets the report. I won't argue over it.
Let's see, is there anything else I'm trying to recall here? Oh, right, so this is another, I mentioned this earlier. So this is remember that, this is over on page 19. Remember the Sentencing Commission is charged with considering whether that additional group of offenses should be part of the Big 12. And the ones you see on page 19, lines 8 through 15, those are the ones that have been moved from section 1 of the bill. That in the Senate version, those had been added to the Big 12, and the House proposal is to not move them right now, right, but have the Sentencing Commission
Well,
look at.
depending upon how we deal with it, what's studied, I don't have a problem with studying trafficking and of drugs and human trafficking. I really don't. As I said earlier, the original version of the bill had 16 to 18-year-olds in it who will be subject to adult court. There may be some ways to work around that. I am not looking to put people in jail. some of these 16, 17, 18-year-olds who are committing serious crimes need to be dealt with. Thank you, Eric.
Sure.
I did provide a copy of a letter from an article in this morning's Bennington Banner. It's on the website. Bennington had 11 overdoses in the last 4 days between Friday and Monday. One of them is somebody who's very close to me. And it's frustrating. The cocaine was laced with fentanyl. The heroin was laced with fentanyl. And the police actually ran out of Narcan Sunday night with the number of overdoses they were dealing with, and had to go get a resupply. This is not pretty, you know. It's not just happening in Bennington, but the article, and you can take it for what you want, look at it, but it's real. Ghost guns were seized, a lot of money, a lot of drugs on Depot Street. That's where I ran my program for 35 years, just down the street from that place. So this is really hitting home, and I am frustrated that the other body has looked at this bill and is removing provisions that I think would help hold some of these folks accountable. That's a personal opinion. And I invite anybody to join me with the Bennington Police Department. Take a walk at the hot spots. Talk to the people who are living in hell. Because landlords will do nothing about the drug tenants in their buildings. And that's another factor that's not even recognized when they took that out. That frustrates me. Those are innocent people who are just stuck in a building and they can't get out of it because of our lack of housing in the state. I really feel for them and their kids. Eric, thank you so much for the walkthrough. Is there anybody who would like to make a comment who's either out there in remote land or here in the room? Yes, State Attorney Tim Lauder Dumont.
Yeah, Tim Lauder Dumont, Department of State's Attorneys and Sheriffs, and I just want to echo your comments, Mr. Chair. It's not just in Bennington County that we're seeing this in all 14 counties. The cross currents of housing, lack of supports in our community are really at a crucial breaking point right now. And we see in particular the carrying of a weapon while committing a felony as being a really important and very germane aspect of the sentence consideration, and appreciated the comments that you've made today on that topic. And I'll also note the attempts by the Legislative Council on the VCRs is appreciated as well for the sake of judicial efficiency of making sure that VCRs connected to very serious offenses are remaining together. And then lastly, the attempts, as you've noted, the attempted sexual assault, the attempted murder, the attempted aggravated assault. These are all very serious situations that we think are meritorious of trending in the right direction and providing clarity in the law as opposed to ambiguity. So we appreciate those comments of the chair today. And that's really it from the department's perspective.
Thank you. Anybody else? Anybody in remote land? Okay. Eric, thank you so much for the walkthrough.
Sure.
We look forward to a final version of the bill before the end of the session.
On June 1st. On June 1st. End of the session.
I hope not.
At the rate we're going.
You know, there are some good things happening. Guy called me, an old friend, and I said, "Can I call you later?" And he said, "Okay, retired guy here, going to play tennis." So, hey, good for you, Barbie. We'll talk to you later. Anyway, the next bill is, I think, F-91.
Yeah.
That's Eric as well. Thank you all for allowing me to vent.
So, yes, as you indicated, Senator Sears, the next bill is S-91, which committee members may recall is an act relating to competency to stand trial and insanity as a defense. Also one that that has come through the House, and I'm not sure if that is here yet or not. Is that in committee yet?
I think they passed.
I thought they did, but it might not have gotten.
Becky, can you check on the status of 91? I think 89 is still floating.
Yes, definitely. They're taking testimony this morning on that one. But I'm not sure. 91, I thought did pass the body. I'm just
Yeah,
not
I
sure if
think
it's in the committee yet.
I think it's coming back to us very soon.
Yeah,
for
it
a-
says on the notice calendar, House proposal of amendment today.
Okay, so it'll be back next week. If you would like to walk us through the,
Yes. So you remember, sort of in the big picture for a moment, you remember one of the primary things going on in this bill is to separate the competency examination and the concept of competency to stand trial from the concept of the insanity defense, two different things. And in terms of the law, there were places where it seems to be merged, in particular with respect to the initial competency examination that takes place when a defendant's mental health status is at issue. And the proposals that came out of the Senate was to separate those things so that initial competency examination would only be I meant to say that initial psychiatric evaluation, although you may recall that also is an element that the Senate is expanding. But that initial psychiatric examination would be for purposes of competency, not for sanity, because sanity is a defense would choose to raise whenever they choose to, as opposed to a threshold issue that has to be decided before the proceeding can continue and before an insanity defense can even be raised. So that was kind of the big picture of what was going on. So you'll see in section 1 over on the top of page 2, as it came out of the Senate, as I was just mentioning, the insanity defense being a defense that the defendant raises, the language is unchanged. That provides that the defendant is responsible for hiring their own forensic evaluator if they are raising the insanity defense. Provided that, as it came out of here, the language said provided that the state shall pay for the evaluation of an indigent defendant. That was just viewed as a little unclear as to, well, who would be the entity, the state entity that would be paying for it. And my understanding is that the Office of the Defender General gets money in their budget to pay for these examinations, and that this is clarifying existing practice anyway, that it is.
I did actually talk to Representative Lamont about that is probably a helpful clarification of who's paying what. Of course, it ends up in their budget.
Right. And the next section, you'll see that the title was changed, and that just reflects under existing law, it says order for examination because it can be for either competency or the insanity defense. But the change you're proposing to make is that it's only that psychiatric evaluation is only for purposes of competency. So that also is really a technical change on line 4 of page 2, just to clarify that that's what this examination is for now, it's for competency. And over on page 3, speaking of the competency examination, there was language similar to what you looked at with respect to the insanity defense just now, saying that the examination, this competency examination, shall be at the expense of the moving party, provided that the state shall pay for the evaluation of an indigent defendant whose competency is at issue. There was some discussion here as to who, because if you read that literally, at the moving party, that would seem, and the court, the defendant, the state can all move for this initial competency evaluation. So there was some
Hard to see the court.
and even also other parties were saying that this initial examination actually is the responsibility of the Department of Health. It shouldn't be by the moving party. And so rather than change the law at all, the decision was made to just strike that, go back to the existing state of the law on that, which my understanding is that DMH does pay for those initial psychiatric evaluations. And you remember that another provision that hasn't been changed by the House, but also on line 3, page 3, lines 12 to 15, this is the provision that allows mental health professionals other than psychiatrists to conduct those evaluations. Remember, as it came out of the
Right.
Senate, you added doctoral level psychologists with forensic training, I think it was.
Going back to I was looking for a cookie and I missed your explanation.
Sure.
On page 4, the court may issue a warrant.
Yeah, I haven't even gotten to there yet, so you didn't miss
Oh,
anything.
We're on page 3.
Oh, I'm sorry, I jumped ahead.
That's all right.
I was gonna ask the judge if he wants to do that, but,
All right. And I'll give them a moment to think
well,
about it.
go ahead. Yeah, thank you.
All right.
Sorry, Eric.
That's all right.
The cookie ruined my thought process.
Understandable. They're awesome. So the new language you see in the bottom of page 3 over on the top of page 4, that deals with what is sometimes referred to as cumulative or subsequent competency evaluation. Because remember, competency is a fluid concept. A defendant who is competent at one moment might be incompetent at another. And a defendant who is incompetent may regain competency and be competent later on. So there may be circumstances where a competency evaluation, even if it's already been done once, circumstances might warrant that there be another one. And so that is the situation that's being addressed by subsection E. And that's saying that basically, if there's already been an initial, there's already been a first competency evaluation, then the court is only going to order one. And again, the court's ordering it, those are the ones that are at DMH expense. The court's only going to do that, and you look at line 18, upon a showing of changed circumstances. So it's not going to be offered sort of as a matter of right. It's a matter of, there has to be a changed circumstances showing before there's going to be a subsequent evaluation ordered by the court for DMH to pay.
So my question about this section, is that decision made by the judge, or would the defendant have to make a motion and say, here are the changed circumstances, please do another evaluation? Or could the prosecutor do that too?
I think you're right that they would motion that, but my reading of that is that, and again, it's a good point that it's not specifically articulated here, but the way I would read that is it being the court's decision as to whether or not the changed circumstances have been established.
Thank you.
Yeah. And the next sentence kind of goes in, and in fact, this sort of supports that reading, because you'll see that next sentence says in determining whether to order the subsequent evaluation. So actually, I suppose that is a little more clear. In that sense, it is clear. It's up to the court to make that order, and it indicates what at least one factor that the court has to consider, which is the treating physician's clinical evidence, if any, indicating that the defendant's competency may have changed. And lastly, just to make clear, the last sentence there is that this only again applies to the subsequent evaluations requested that the court order it for DMH to pay for. The last sentence makes it clear if the parties want to get their own subsequent evaluation, pay for it themselves, they can still do that. That doesn't limit that ability. And now, Senator Sears, we're moving on to subsection F, the one you mentioned about the warrant. This is a situation where the psychiatric evaluation has been ordered. The defendant gets notice that the evaluation is going to take place, and they fail to appear. So this provides the court with the authority to issue a warrant in that case to order the defendant to appear for the evaluation.
Okay, and that's where I had the question about whether, I mean, it starts a precedent that if the defendant misses an appointment, and I understand the backlog and the difficulty of getting these appointments for competency examinations, but I wonder if we're setting a precedent here. I know a lot of people miss appointments who are required by the court to go here, go there, meet with a counselor about your drug problem, whatever. I'm asking you, Judge, if this is a precedent that you're comfortable with.
Tom Zoney, Chief Superior Judge. The initial iteration of the language about warrant actually said the court shall issue a warrant if someone does not appear for an evaluation. It did not include any language even about notice. So I testified before the committee, and this language effectuates what I understood the intent of the committee was. And that was to provide the judges with the ability to issue a warrant if someone does not show up. The concerns that you are expressing, Senator Sears, are ones that I think are well placed. And that's why, from my perspective, it's very important that it not be a shall for a warrant, but it gives the judge the discretion. I also think that I would hope, put it that way, that as a practice pointer, and the training I would give the judges under this is that, yes, you have the ability to issue a warrant once there's notice, but it would be hopefully, you would most likely have a hearing to determine, did they get notice? In other words, simply getting a letter or an information saying the person did not show up for the evaluation does not tell the judge that that person did or did not have notice of that and that was received. So my thought would be that what would happen is you would schedule a hearing anyway. And if they did not show up for the hearing, you could issue a warrant for them not showing up for the hearing, which gets you to the same end result. Some judges at this time have been utilizing that technique. In other words, when they find out when the evaluation is, they may schedule a hearing to occur at or about that same time, so that if the person doesn't show up for the hearing, they most likely haven't showed up for the evaluation, then a warrant could be issued for them not being in court. But as written here, if that's the direction the committee wants to go in to give the court that authority, I think that it, again, I would hope that it's utilized after hearings, and we really have to make sure people get notice, because we do not want to start issuing warrants without adequate information that someone absolutely did not show up. And one of my concerns also was that you could have a circumstance where they were trying to sign on for the remote hearing and it didn't work. So we have to be very concerned about that.
I like this last line where it said the judges may have this, but the Defender General's office brought up the point of when you had mentioned Judge Zoney about did they receive notice that due to the COVID and many other things that people had moved, they couldn't find them, they couldn't locate them, or whatever else. So if you have that hearing, as you say, to show up to see if they receive notice, how do you expect to notify them? In fact, those same circumstances still exist.
When someone appears for an arraignment, they have an obligation to let their attorney know, or the court know, if they're not represented by counsel, where they are residing and if they change their address. And so at that point, and I recognize that individuals lose touch with their attorneys over the extended period of time, but at that point, there is a responsibility they have to be in court. If they do not keep up with their attorney and let their attorney know their information, and their attorney makes efforts to contact them, they don't show up here, the court has the authority at that time to issue a warrant. If it was any other way, we basically have a system whereby if someone just loses touch, we never get them back again because we can't issue a warrant. So even if this section F were not included, and we had someone under those circumstances, the court would still be justified in issuing a warrant to bring them back, if you will, into the fold to try to address the case that's before us.
Yeah, and my concern with this section is, as a, for instance, if somebody has caused bodily harm to another person or whatever else, and there was a competency hearing ordered to see if he or she could stand trial. If we can't locate these individuals, we have no idea where they are, and they very well may or may not be competent to stand trial. I just don't want that individual out running at large for their safety, along with the general public safety. So I like the, they may issue that, because I think both parties need to be cared for in this particular situation.
I would also offer that one of the things we're trying to do, this ties in if you will to the backlog, because of there's a backlog of competency evaluations. What we're trying to do is have the hearings tightened up with time. So that we get the evaluations done, we get the individuals back before the court, which minimizes the risk of them losing contact with their attorney. And even in cases that do not involve competency evaluations, we're trying to tighten up those lines, and we're trying to get people back in, because Mr. Valerio has testified quite a bit about that they've lost contact with some people. And so we are taking steps to try to bring people back in, to get the court back, if you will, to where it needs to be, or what we would call the pre-pandemic. And as people showing up for court when they're supposed to.
I'm personally comfortable with the permissive aspect of it, and that mitigates the other problems for me.
I mean, I think I expressed my concern with it last time, just, this is a person who is so mentally ill, they are potentially incompetent to stand trial, and further criminalizing that concerns me.
I'm just, to the judge's point, I'm just thinking about how you would get them back into the system if you're not issuing.
Yeah, I hear your concern, Senator Bohosky. I don't know that this is necessarily further criminalizing a person, I don't see that there's punishment for not appearing. Rather, it's an attempt to make sure that the person does appear for their evaluation.
I know that an arrest can be viewed as not punishment, but, I mean, I have concerns with it. That's all.
That is all.
I'm fine with it.
You want to go on?
Sure. You'll see the next several pages, you see no changes. This is really just continuing with the same theme of separating the competency evaluation, the competency process from the insanity defense process, making clear again that it's that the competency issue was one that can be raised by any party, where the insanity defense is raised only by the defendant, so the proceedings are separated. So that'll move us right to page 10, which is the competency restoration program plan. You remember this is a piece that DMH and Dale are required to report back on whether or not a competency restoration program plan should be adopted in Vermont. And if so, recommendations would be included for best practices, changes in law, et cetera. The only change to this one, and this goes from page 10 to page 11, the Senate version of the bill indicated that DMH and Dale would be having to produce this report in consultation with interested parties. That's on line 19 of page 10. And what the House version did was just, rather than saying just interested parties generally, it identified who they would be. And those are over on page 11, lines 6 through 12. So the Chief Superior Judge or designee, Commissioner of Corrections or designee, Executive Director of Departments or States Attorneys and Sheriffs or designee, Executive Director of Center for Crime Victim Services or designee, and Defender General or designee. So, and lastly, for that piece, also adding a particular point that the DMH would have to consider, which is give consideration to providing notification and information to victims of record. So those are the proposed changes there.
So I had raised last time that the study committee seems too narrow to me and doesn't seem to represent the voice of medical providers. It seems really criminal justice focused. And I certainly understand that that is an aspect of this bill. And when we're talking about mental health evaluations, we're also talking about medical care. And so I feel like some voice from the providers that do these evaluations or that is important on this committee.
And this is just my lack of knowledge here, but in response to that, it does say the Department of Mental Health and Dale would consult with. So are there additional mental health providers or medical providers that are missing?
I mean, I don't know if the medical society might be able to let us know. It just seems really heavily skewed in one direction that is not taking into account that we're also talking about a medical determination. And I mean, the other piece for me too is people with lived mental health experience. I mean, this is a group of people that can be criminalized for their behavior. And so it just gives me pause that there may be some voices missing from this study committee or study group.
I'm just trying to look at your skewed version when I look at the Department of Mental Health in Dale.
Yes, it's one.
The Executive Director for Vermont Center for Crime Victim Services and the Defender Generals or designee And then there's, I'd say 3 there and 3, there's 6 individuals or agencies identified here. I just wonder where the skewing comes in here, that's all.
So what I see, so the Defender General is within the criminal justice system. The Department of State's Attorneys and Sheriffs is within the criminal justice system. The Commissioner of Corrections is within the criminal justice system. The Chief Superior Court Judge is within the criminal justice system. The Department of Mental Health is within the healthcare system. So we have one person from the healthcare arena and everyone else is criminal justice.
Well, what about
Well,
Dale?
and Dale.
Okay, so two.
And the Director of Vermont Center for
Well,
Crime
your
Victim
point is well
Services.
taken, but it's 2.
Two, it's
We're
still
pointing out
not.
to you that it's 2, not.
What about the third one?
The
Well, I
Center for
think-
Crime Victim Services also really within the criminal justice system, not the healthcare
Well,
system.
They're representing the victims of.
Yes, and I'm not saying that it shouldn't
Yeah,
be there.
yeah. Who else would you like? The disability rights community representative,
That would be great.
the, I'm drinking off the top of my head.
Yeah, I know, me too. Let me put out, I'm gonna ask a couple people who they think should be there and can I come back to?
That- Yeah, absolutely. What's the status on that? It's already passed. It's on the notice calendar.
Yes.
Notice today.
Yeah, so we've got a few days.
Okay, so I'll put out a couple feelers and come
My-
back with.
My thinking is that we would concur, and if you have further proposal amendment on the study, we could concur with that.
Sounds good. Thank you.
Because I understand why they did what they did. They were under tremendous pressure from the health care committee if they tried to add Dale patients.
We do have a hand up and.
Oh, I'm sorry, Karen, Barbara?
Yeah, good morning. Karen Barber, General Counsel for the Department of Mental Health. I did just want to let you all know that we don't see this as an exclusive list. The Vermont Medical Society did reach out to me and wanted to make sure that they would be included. We had certainly planned on that. I said I wasn't sure if they wanted to add language. We were fine with that. We planned on doing that anyway. We work pretty closely with Dr. Robin. I think she's testified in front of you. I'm so happy if you want to add them. That was certainly our intention anyway, but I certainly don't oppose it if you want to add that language in there.
Thank you.
Thank you. So other than that,
Yep, couple of last little matters that are pretty brief centers here. So you'll see also, you may recall that this is section 8, has the Justice Oversight Committee look at that concept that I was mentioning earlier about should other mental health professionals be able to provide those initial evaluations. But again, they would only be regarding competency, not sanity. So that's why it's just a technical change that.
who's the new member from here of Justice Oversight? Is it you, Bob? I'd like to be chair.
Well, I wasn't entertaining the thought of running for chair, Senator Sears.
It's a Senate's term.
Okay, duly noted.
Thank you.
Meeting tomorrow.
Meeting tomorrow at noontime. So I don't have a problem with Justice Oversight looking at this issue. Personally, with all that I said about them around S4, I compliment them on their work on this. By and large, I agree with Senator Bowski about the study, but other than that, I think is any comments from anybody in the remote or in the room in terms of where this bill is ending up? Yes, Karen.
Thank you. I would just like to say that, we really appreciate all the time and effort you put in. DMH and AHS and Dale strongly support the bill and would urge you to vote on it as is. We worked really hard with stakeholders to come to some language changes that you saw in the House. And we think it's a really good and important bill. I did just want to touch briefly on the warrant issue. It sounds like maybe some of your issues have been resolved, but I just wanted to kind of give some context to it. So in this week alone, one of our 13 evaluators has already had 4 no-shows. So just it really is a large problem for us. We do try to remind people, I think the language we've worked out is may, so that there is some flexibility. As I understand it, the Defender General doesn't object to the language. I think it does give the court flexibility, and we don't expect the court's going to issue all these warrants. But for example, one of these people has no-showed 3 times, right? Despite a court order requiring them to be there. So it is a big issue. I don't think we're going to see a lot of warrants, but we do think it's an important tool when it's necessary. I did just kind of want to support that provision and also the bill as a whole. So thank you for, again, for all the time and effort you put into it.
Thank you. Anybody else? Any comments on S91? I would suggest that we wait until they pass the bill and then we'll have a discussion next week. We'll try to meet, we'll try to find time to meet on Tuesday.
You talking about S4, Senator?
Pardon?
You talking about S4?
Yeah. Well,
I imagine that's gonna go to conference, yes.
well, unless we can make some deals, I'm gonna try to deal with it.
Okay,
But Eric, I'm talking about S91, if you have anything, that we could try to meet on Tuesday at some time. But we'll definitely meet next Wednesday morning from 8:45 to 9:45, and then Thursday and Friday. And hopefully, I want to mention one thing while we're still live. Our wonderful committee assistant who's been with us for quite a while is leaving us to retire. And I'm all in favor of people retiring. And I hope she does all the things she wants to do in her retirement before she gets so old that she can't do them anymore. But I just want to publicly, while we've got a crowd here, thank Peggy for all the work she's done over the years with this committee. And I think everybody in this room and everybody who's worked with you who are remote, want to thank you as well, Peggy. You've been terrific. We love you. Thank you so much.
Thank you. I'll be here till the end of the year. I miss you guys, especially you, Senator.
Oh, thank you. I'm gonna miss you, but I wish you all the best in your retirement. And you controlled me when Michelle couldn't.
No, it's been.
Back in the day, Michelle and Eric used to have the grumpy report.
The grumpy report.
Yeah, what mood was I in? And they would report it to the.
I've done a little bit of that myself, just giving the old someone lucky and I'm like, no, not a good time. So we've had quite a ride, Senator Sears, haven't we?
We have.
It's
So,
been great. And as I told him, I'm hoping to come back as a committee assistant, not next year, but the year after. And maybe so.
Well, I don't know who will be here.
Who knows? I may not.
You may enjoy retirement.
I know.
I mean, I will say, my wife and I, and I think everybody knows about my wife and the condition that she can't travel, and basically the neurological disease is taken off. We are so fortunate that we did things like cruises to Europe, cruises to Alaska, trips to Las Vegas, which we won't mention how much I won there.
Yeah.
Trips to Sarah. I mean, we did a lot of things, and I
at least
encourage
she was
people
yesterday.
to do those
Evening
things while
when I
they
talked to her.
can.
Yeah,
So,
that's the big reason why we're doing it.
yeah, you never know what's gonna
Physically
come.
do the things we want to do.
So, but anyway, with that, I think we'll take a brief
I don't-
break till 11.
I think she
We have a bill.
Yeah, I know.
Oh, okay.
We'll pick it up at 11.
Okay.
And can you, who's subbing for
I
Ben
checked with Owner.
on S14?
I don't.
Can you do
think
that
she can.
this morning, S14?
Oh, S14
Yeah.
Maybe.
must be Eric.
Oh,
Yeah, that one's fine.
Yeah,
I thought that one you
okay.
already-
Yeah, I don't
that one
know.
you already looked at. I
What?
thought that one you already looked at. You already.
Okay.
last
Oh,
time
I
I
asked
saw
her
you-
yesterday.
We already had for conference committee?
Yeah.
Yeah,
Oh, can we look at S6? Who did
Yeah.
that?
Michelle.
That's,
why
yeah,
she's
that's
here.
why I'm
okay.
here.
Okay, we'll look at S6 after.
Okay, at 11? Or
At
now?
11, yeah, is that okay?
Put it on the wall.
Sure.
Good.
And work on
I don't know.
it. Anyways,